in any UN documents are the three from this region. Security Council Resolution 237, June 1967, 242 in the November, and 1559 of 2004. I don't know how familiar you are with documents from the United Nations. The area of law we are in, the United Nations is a significant legislating force, and I was going to show you some of these documents, like this, which is the most cited resolution in UN history, just so that you could see it and have a look at it and see how it was drafted. And you'll notice a change from 1967 to the present day as I pepper a few of these in this morning in this particular talk. There was the 1967 237 resolution after the Arab-Israeli conflict had led to the defeat of the Arab forces, and the government of Israel was required to ensure the safety and welfare of inhabitants where military operations had taken place, and that there be scrupulous respect for humanitarian principles concerning prisoners of war. And then we moved to 242, which was in the November, and a significant document that we have to look at. And that wanted the withdrawal of Israeli armed forces from those territories occupied in the conflict. So behind all this, for many years, since 1967, Israel, Syria were in breach of a UN law. And this is international law that is being passed here in the form of UN Security Council resolutions. Not taken so seriously in those days as it is now. The United Nations has galvanized its force as an international presence and has made its resolutions more accountable to the states who are states parties of its charter. So forces were requested to be withdrawn in 242 of 1967, and in 1559 resolution 2004, the UN was still calling for the strict respect of sovereignty, territorial integrity, unity and political independence of Lebanon, and wanting the territory under the sole and exclusive authority of the Lebanese government, and called upon all remaining foreign forces to withdraw from Lebanon. So the objective of the UN is always to have a strong, independent, sovereign Lebanese state. These expressions and phrases here come up time and time again in all the resolutions dealing with Lebanon passed by the Security Council. So there you are. There's three resolutions over a period of 30, 40 years dealing with the issue that eventually turns into a point of conflict, if you like, concerning Lebanon. Let's move from this, having looked at that background, history, and the international legal relationships, to terrorism and measures taken in international law. We have national legislation concerning terrorism. Terrorism in international law has many statutes passed by the Security Council, by the General Assembly, many conventions, and we will look briefly at those as they are part of the background, because The Lebanese tribunal is a tribunal concerned with terrorism, not war crimes, not crimes against humanity, but a nationally based crime of terrorism. So it is not in the universality league of crimes against humanity, those universal crimes, but a specific form of crime that the United Nations has moved its state bodies into trying to deal with on an international level. I've taken a few significant conventions just so that you know about them and you know they're out there, because they're part of the background you should understand. 1998 International Convention for the Suppression of Terrorist Bombings, requiring states to cooperate together, not to sponsor terrorism on their own territory against another state, to respect the rights of states and their sovereignty, not to be the subject of terrorist plans being manufactured or hatched in another state, and seeking greater cooperation amongst states to suppress terrorism, all arising from the Palestinian cases, IRA cases, Shining Path case, all those big organizations which caused certain states great problems from the 1970s onwards. Article 10 here sets out greatest measure of assistance in connection with investigations of criminal or extradition proceedings brought in respect of the terrorist offences in Article 2, and assistance in obtaining evidence for court proceedings. And states have to carry out those obligations in conformity with any treaties or other arrangements of mutual legal assistance. And all states shall afford assistance in accordance with their domestic law. You can see the progress of the UN since the Second World War, when it changed from being the League of Nations and became the United Nations, gradually becoming a superior governmental organisation, if you like, creating laws, creating legal responsibilities, and requiring states to abide by them. You see that development from the 1950s. Rather than being the club it was then, of states just talking together, as international problems grew in their dimension, and states, as people travelled more freely, less restrictions, people could get information from one place to another, global problems spread and required global solutions, and the United Nations started turning itself into a legislative body that states were caused to respect under the Charter of the United Nations, respect laws that were passed by them, and take necessary measures. General Assembly resolution in 1998. This was following on the International Convention to Suppress Terrorism, measures needed to eliminate terrorism. Security Council resolution 1373, passed after 9/11 in 2001. Now in modern times, one of the most famous UN Security Council resolutions, condemning the bombing of the Twin Towers in New York, requiring states to reaffirm that acts like acts of international terrorism constitute a threat to international peace and security, requiring states states to take steps to prevent international terrorism, and gradually the Security Council was focusing upon states who were sponsoring terrorism. Taliban hold up in Afghanistan as it was then. And so gradually measures became more threatening. Rather than general condemnation requiring states to cooperate, you see a narrowing of the position as the Security Council, the big states, start getting fed up with what's happening and are requiring specific measures to be taken. And a global counter-terrorism strategy was developed in 2006. Provisions were developed concerning the blacklisting of individuals who were not allowed to travel from one state to another. There's a register in New York where named people are, where assets have to be seized. There's a special commission run by the United Nations, and people who are blacklisted on it have to go and represent to the special commission run by the Security Council as to why they shouldn't be on this list. All this is derived from Chapter 7 of the Charter of the United Nations. And for international criminal lawyers, this again is one of the most important documents and passages of law that needs to be looked at and seen. Because it's from Chapter 7 that the authority was derived to enable it to set up the ad hoc tribunal for Yugoslavia in the first place, and then moving on to Rwanda, and also applied here in Lebanon. It's where the power is derived from, and I want you to have a look at this because this is important background information. Under Chapter 7, the Security Council has power to take action with respect to threats to the peace, breaches of the peace, and acts of aggression. Article 39 within Chapter 7 entitles the Security Council, if it determines that there is a threat to the peace, or breach, or aggression, that it may make recommendations or decide what measures shall be taken in accordance with Articles 41 and 42 to maintain or restore international peace and security. Earlier this morning, when I referred you to the Tadic jurisdiction judgment, most famous judgment, in fact, that gives the authority or confirms the authority of the court set up by the United Nations, the argument was all over this particular area here, Article 39, Article 41, and Article 42, as to whether these measures included the ability to set up a court. Was setting up a court something you would describe as being a measure? Because measures in Article 40